My name is Jess Johnson. I'm a criminal defense lawyer in Atlanta, Georgia, and I've been handling criminal appeals in Georgia for the past 15 years. Now, my firm has had great success both in the Georgia Supreme Court and the Georgia Court of Appeals. But over the years, I've noticed that a lot of my clients and a lot of criminal defendants in general just don't have a very good idea about Georgia's appellate system and how it works. And so the purpose of this video is to help you have a better understanding of Georgia's appellate court system and how your case in particular is going to move through it. And I want to start with the structure of the courts. At the very bottom, you have the Superior Court. This is also known as the trial court. And this is where most of the action happens. This is where someone is indicted. This is where someone goes to trial. This is where someone is convicted and sentenced by the trial court. Now, after someone has been convicted in the Superior Court of a felony offense, they can appeal their case. And Georgia has two different appellate courts. The first is the Georgia Court of Appeals, and this is where most people convicted of felony offenses will first appeal their offense. If that fails, they can then appeal up to the highest court in Georgia, which is the Georgia Supreme Court. Now, the Georgia Supreme Court does hear some cases initially, but those are generally going to be capital cases, such as a murder case. Otherwise, you're probably going to directly appeal first to the Georgia Court of Appeals. So if the Georgia Court of Appeals rules against you, and you've asked for reconsideration or a rehearing en banc and they've denied all of that, your next step is to appeal to the Georgia Supreme Court, which is the highest court in Georgia. Now here's the thing, the Supreme Court of Georgia doesn't have to hear your case, but it can. And so what your lawyer will do is file something called a petition for certiorari. And that's essentially asking the Supreme Court of Georgia to give your case consideration, to hear your case. So the question comes up a lot, how do you actually appeal to the Georgia Court of Appeals? Well, it's not automatic. There is something that needs to happen. And what needs to happen is within 30 days of your sentence, there needs to be one of two things filed. One is either going to be a motion for new trial, or the other is going to be a notice of appeal. And there are different reasons why you might file one, but typically speaking, after a jury trial, you're going to want to file a motion for new trial. The reason why is that a motion for new trial gets the case back in front of the trial judge. And in that motion, you essentially explain to the trial judge the errors that occurred at trial, and you're asking that judge to give you a new trial because of these errors that occurred. If you only file a notice of appeal, your case goes immediately to the Court of Appeals, or if it's a capital case, to the Georgia Supreme Court. And so you're essentially missing that step, getting your case back in front of the trial judge to give you a shot at a new trial. And in some cases, the trial court judge is more likely to grant you a new trial than the appellate courts. So we talked about you having that 30-day window to file a motion for new trial or a notice of appeal. If you're going to be filing the motion for new trial to get the case back in front of the trial court to see if the trial judge will give you a new trial, then normally what you're going to do is you're going to file a very bare bones motion for new trial. It's only going to list a few general errors, such as the weight of the evidence was contrary to the verdict, something very general. What's going to happen, though, is that's going to preserve your right to amend or to change that motion for new trial down the road. And there's a number of things that have to happen before that motion for new trial is actually heard by the trial court judge. The lawyer is going to review the transcripts. He's going to review all the evidence in the case. He's going to talk to the witnesses who testified in the case. He'll try to talk with the assistant DA who was trying the case. And his job is to fashion together the errors that occurred, the errors that are going to get you a new trial. And once he's been through that process and he's come up with these errors, he's going to file what's called an amended motion for new trial. And that amended motion for new trial is going to spell out every single error that occurred. There are a whole host of errors that your attorney could raise in the amended motion for new trial, but typically these errors are going to be classified into three groups. The first group would be a judge-made error. So the judge during the trial allowed a piece of evidence in that he should not have, and that would be a typical example of a judge error. It's called a trial court error. A second group of errors would be errors made by the state, errors made by the prosecution before and during the trial. And a classic example of this would be a Brady violation, and that occurs where the state withholds favorable evidence from the defense. The third type of errors would be errors committed by your trial lawyer during and before trial. This is called ineffective assistance of counsel. And what that means is that your lawyer did something that he should not have, or that your lawyer didn't do something that he should have. Once your lawyer has filed the amended motion for new trial, the judge will set the matter down for a hearing. This hearing will be an evidentiary hearing. And what that means is that your lawyer will have the opportunity to introduce evidence into the record. And this evidence will be by way of testimony or documents or whatever the lawyer has to support your argument for a new trial. Once the hearing on the motion for new trial is over, the trial judge will make a decision. He can grant you a new trial, or he can say no and deny that request. If the request is denied, if your motion is denied, your next step would be to file a notice of appeal, and you would once again have 30 days to file that notice of appeal from the date that the court enters the order denying your motion for a new trial. The notice of appeal needs to tell the clerk of court in the trial court several things. First of all, they need to tell the court what to include in the record. And in most instances, this is going to be everything. All the trial transcripts, all the evidence, everything that's in the record should really be sent up to the Court of Appeals or the Georgia Supreme Court. The notice of appeal is also going to tell the clerk which court to send the case to. After the notice of appeal gets filed, the Court of Appeals will issue what's called a docketing notice, letting the parties know that the case has been docketed in the Court of Appeals. And the docketing notice will tell the parties when their briefs are due. Normally, the appellant, the defendant, the criminal case usually, is going to have 20 days to file his or her brief in the Court of Appeals. Your lawyer will likely request to have oral argument in the case. An oral argument is where your lawyer shows up at the Court of Appeals at the courthouse and argues before the three-judge panel as to why you should get a new trial or why your sentence should be vacated, whatever it is that they're arguing before the Court of Appeals. It's important to note here that the Court of Appeals does not grant oral argument in every case, and in fact, in most cases, they do not grant oral argument. After the issues have been briefed by the parties and after the court has considered oral argument in the case, it will issue an opinion. Opinions issued by the Georgia Court of Appeals will usually set out the facts of the case as the court sees them, and then the court will address each argument raised by the defendant on appeal. And it will explain why, under the current law, they agree with the defendant or don't agree with the defendant. If the Court of Appeals disagrees with you and your lawyer, and it upholds your conviction, upholds your sentence, whatever it is that you are appealing, then you can ask the court to reconsider. And that's proper when the court either misconstrued facts in the case and got it wrong at a factual level, or if the court forgot about an important case that was out there that should have controlled and didn't, or if there's been recent developments in the case law that it looks like the court didn't take into account, then you can ask the court to reconsider its decision. If the court disagrees with you and rules against you, at that point, your only option is to let the court know within 10 days of its ruling that you intend to petition the Georgia Supreme Court for a writ of certiorari. And then you have 20 days from the Court of Appeals opinion to file a petition for writ of certiorari in the Georgia Supreme Court. At that point, the Georgia Supreme Court is going to consider whether it wants to hear your case. If it does want to hear your case, then it will ask the parties to submit briefs on the matter, and it will also hold oral argument on the matter before ultimately deciding what to do with your case. So that's a general outline of how the appeal process works in a Georgia felony criminal case. If you've been convicted and sentenced, or you have a loved one who has been, give us a call. We are happy to help.